Greetings, this is our Company Law Group presentation. We will be analyzing the extent of which the Companies Act 2016 has successfully achieved its objectives in Policy Statement 9 under 4 categories: oppression of members' rights, statutory derivative action, class rights and preference shares, and finally, dividend. Each change discussed will relate to each principle stated. We will now proceed to the presentation.
Previously, members in general meetings do not control the powers of management which fall within the director's powers. This is modeled after Table A of the UK Companies Act 1948 into the Companies Act 1965, which upheld the director primacy model. This model operates to limit shareholders' decision-making powers as director primacy perspective regards the corporation as a vehicle which by the board of directors hires capital from selling equity and debt securities to risk bearers with verifying taste for risk, which are the shareholders. The Companies Act 1965 depends heavily on the Article of Association (AOA) for making decision-making powers, but in general, the directors are vested with powers to decide on management issues. Article 73 of the Table A provides that directors are empowered to decide on all matters except those expressly reserved for the members where the company can adopt a provision under the AOA to do so. The case of Tengku Datuk Ibrahim Petra bin Tengku Indra Petra 2018 considered the issue of separation of powers between the directors and the shareholders in a general meeting under the Companies Act 1965, which was whether the directors' powers of management can be overridden by the simple majority of the members by passing an ordinary resolution. The Federal Court provided negatively, stating that this can only be done through alteration of article, as Section 131B states that business and affairs must be managed by the direction of the Board of Directors. Meanwhile, under the common law, according to the case of Isle of Wight 1884, the board acts as a company's agent and is subject to the control of the members in general meeting, who was considered to be the supreme organ of the company. However, momentous transformation is observed where the Court of Appeal in Automatic Self-Cleansing Filter Syndicate 1906 held that where the board exercises their power in accordance with the Constitution, the general meeting cannot impede their lawful exercises. This proved that previously a shareholder's right in decision-making powers is miniature and can only be enhanced through the alteration of the AOA. On the other hand, the Companies Act 2016 has brought prominent change. Section 195 of the Act conferred powers to shareholders in influencing the management of the company. This provision allows for a recommendation to be made by members in general meeting to the board, but it is not binding. However, the essence of this section lies in subsection 3, which allows recommendation to be binding if the right to do so is provided in the Constitution or a special resolution is passed. The first element is that the recommendation is in the best interest of the company. The evaluation is subjective, making it difficult to prove what is applicable. Referring to common law, in Mills and Mills 1938, Justice Dixon described best interest as best interest of the company, not for some private advantage of any purpose foreign to the power. This is supported by Lord Green in Smith and Facit 1942, who added that directors should exercise their discretions bona fide, where they consider not what a court considers and without any collateral purposes. Upon satisfying this element, the second requirement is either the provision of the rights to make recommendations are in the Constitution, or that it is passed as a special resolution under Section 292 of the Act. Examining this provision, it is noticeably not difficult to make a recommendation binding, as passing a resolution or including the recommendation rights by members are merely procedural, and the interpretation of best interest of company is relatively wide, as per the business judgment rule that precludes the court from the commercial wisdom of the decision made. The recent case of Majlis Amanah Rakyat and Datuk Abdul Rahim bin Abdul Halim 2019 showed an example of the application of Section 195 and concluded that despite Section 211 providing the board with the right to business affairs, Section 195 provides the right to review by the members. Although Section 195 is subjected to certain provisions like Section 309 and Section 311, it still provides a chance to make a binding recommendation to the management decision which enhances shareholders' rights. Despite the fact that Section 181 of the 1965 Act was brought over by Section 346 of the 2016 Act, the new incorporation of Section 195 has impacted the oppression of members' rights, as now their rights are enhanced, allowing them to make recommendations or even binding recommendations on the management of the company. Thank you.
Derivative action is an action brought by the shareholder or director of the company in the name of and on behalf of the company in respect of the wrong done to the company, rather than to its shareholders. It is derivative as the party bringing the action derives the rights from sue the company. In situations where the alleged wrongdoers are the directors who control the company, the law gives shareholders the ability to commence an action on the company's behalf, thus promoting managerial accountability while boosting investors' confidence. Before the Companies Act 2016, which were known as CA 2016 later, common law derivative action was recognized in court but was inadequate in protection. The common law rule in Fos and Haberdos states that if the company suffers a wrong, then prima facie it should bring an action since it had a separate legal entity from its shareholders, leading to many complex requirements. Cockery has summarized this to be the need to identify wrongdoers, gather sufficient information, show fraud, proof of the wrongdoers' control of the company, funding the action, and ratification requirements, which leave many grievances unremedied. However, the issue is not as clear-cut under the statutory derivative action, which bypasses the narrow Fos and Haberdos rule after the year 1973 amendments. But they did not abolish the common law derivative action, which remained preserved under the Section 181A sub-3 of the CA 1965 and is silent on other areas such as multiple derivative action. The leading case for statutory derivative action in Malaysia is the Court of Appeal decision in Sakor Malaysia Berhad and Muhammad Suhaib Ishak. The court held that the leave to commence a statutory derivative action under Section 181A of CA 1965 must not be lightly granted, and the High Court judge had erred by adopting a low threshold of merely determining if there exists a prima facie case. The court ruled that the provision must give a restrictive interpretation and the applicant must strictly satisfy the requirement that the complainant must be acting in good faith, and it appears prima facie to be the best interest for the company that the application for leave be granted. With the implementation of the CA 2016, the common law derivative action appears to have been abolished according to Section 347 sub-3 supported by the Federal Court case of Perak Integrated Naval Service Sdn Bhd and Urban Domain Sdn Bhd. Therefore, the complainants are only allowed to bring the statutory derivative action, which streamlines the process of bringing an action. Additionally, Section 350 sub-C of CA 2016 allows for the complainants to obtain evidence by accessing board documents and management accounts, whereas Section 350 relieves the burden of cost of the complainant by allowing the company to finance reasonable legal fees. This reduces the considerable hurdles present to complainants in bringing an action under common law, and increases the scope of shareholder intervention and facilitating actions for wrongdoings. However, the requirements of statutory derivative action still parallel with CA 1965. Section 347 sub-1 of CA 2016 enables the member the court permission to sue on behalf of, intervene, or defend of a company, whereas Section 348 sub-4 of CA 2016 is similar with Section 181 sub-4 sub-8 of CA 1965, will have courts consider whether the complainant is acting in good faith, and it appears prima facie to be the best interest of the company to grant leave for derivative action. Section 348 sub-3 of the CA 2016 further provides that the complainant should initiate the derivative action within 30 days from the grant. To ensure that the complainant is serious in filing and conducting the derivative action, Section 348 sub-5 of CA 2016 provides that derivative action once commenced cannot be discontinued, compromised, or settled without court's leave. While these leave requirements act as safeguards against abuse of unjustified litigation and preventing floodgates, derivative action under the CA 2016 is still subject to the same strict requirements of good faith and best interest of the CA 1965. In fact, it was found that 2008 to 2015, the success rate of the statutory derivative action was 38%, less than the 50% success rate of the common law derivative action. As the threshold for leave under the statute is higher than one under the common law, especially since the Celcom case is still used as seen in Salina binti Muhammad Syukur and MVD International Sdn Bhd 2018, the courts may have adopted a less restrictive view in allowing derivative action to better enhance shareholder protection as it is still inadequate.
Generally, ordinary shares and preference shares are the most common types of shares issued. Several distinctions exist between them, and this gap is widened after the change in the rules regarding issues of new shares that will now constitute a variation of class rights. This is crucial as only an issue amounting to a variation can be challenged and set aside under Section 93 of the Companies Act 2016, hereinafter referred to as CA 2016. In Companies Act 1965, hereinafter referred to as CA 1965, Article 5 of Table A in the 4th Schedule states that issue of any shares could be considered as a variation provided that this is expressly stated in the Constitution. However, Table A is superseded in CA 2016, and Section 91, subsection 5 of this Act states that only the issue of new preference shares ranking equally with existing preference shares is a variation of class right, except when the Constitution or the issue of the existing preference shares authorize the company to do so. This change reiterates the common law position as laid down by White and Bristol Aeroplane Company, where the court held that the issue of new shares other than preference shares is not a variation because legally each shareholder's right to exercise one vote per share has not changed, although their voting power may be diluted in a business sense. However, it's highlighted that the fact that the issue of new ordinary shares not amounting to a variation of class right is not of great concern, since Section 75 of CA 2016 still requires ordinary shareholders' approval for any new issues of shares. Moving on, the major difference between the positions of preference shareholders pre and post CA 2016 resulted from the omissions of equivalent provisions to Section 148 subsection 2 of CA 1965, particularly its proviso in the 2016 Act. The proviso allowed the preference shareholder the right to attend any general meeting and set out the limited circumstances where they have the rights to vote, which are A. when their dividends are in arrears and unpaid, or B. when the variations of the rights attached to such shares is concerned, or C. when winding up of the company is concerned. Due to the omissions, the positions of A and C under CA 2016 is unclear. As for B, reference can be made to Section 91 to Section 96 of the new Act. It is highlighted that in 2019, the Company Commissions of Malaysia actually clarified on their FAQ page for general reference that preference shares may still carry certain voting rights, provided that such rights are specified in the constitutions in accordance with Section 90, subsection 4 of the new Act. However, the answers have to be tested in courts ultimately. Hence, the position regarding preference shareholder voting rights should be clarified in the future, since such rights will be beneficial to preference shareholders. Another change on preemptive rights of new shares is noteworthy as it is interconnected to the discussions earlier, since issues of new preference shares constitute variations of class right. In CA 1965, there is no explicit provisions on preemptive rights. Its concept was only addressed in Article 41 of Table A if it is included in a company's memorandum and articles of association. In CA 2016, Section 85, subsection 1 provides that any new shares to be issued by a company must first be offered to the existing shareholders in accordance with the shareholding ratio subject to the Constitution. This is a positive change as it prevents the dilution of existing shareholdings by giving them the right to subscribe for new shares to maintain their shareholdings proportionately. It also protects their voting power by giving them the chance to participate in the issuance of new shares. However, to further strengthen the protections of shareholdings rights, the disapplications of preemptive rights should be reformed, since the ability of the company to disapply the preemptive rights by way of an ordinary resolutions under Section 91, subsection 2 of CA 2016 is prone to be abused. As concentrated shareholding structures is very common in Malaysia, It is easy for the controlling shareholders to get the sanctions of the general meeting to waive or disapply the preemption strike clause. Hence, a better approach is to impose a higher threshold for the disapplications process by substituting it to a higher voting percentage. In short, the extent of CA 2016 achieving its objective compared to CA 1965 doesn't seem to be quite large despite the exclusions of ordinary shares constituting aberrations or omissions of the equivalent provisions to Section 148 Subsection 2 of CA 1965. A relatively more favorable improvement is the creation of statutory preemptive rights by Section 85 of the new Act, although further reformations are still required.
Another method of enhancing shareholder rights is by regulating the remuneration of directors. Before the 2016 Act, the common law adopted a general non-interference policy over remuneration, as seen in the case of Rehalt Garage, where it was determined that such tasks are decided by members of the company, either by general meeting or by the board of directors. Meanwhile, under the Companies Act 1965, there was no specific provision on directors' remuneration. Instead, articles were introduced to regulate it under Table A of the 4th Schedule, that is, Article 91 and Article 92, which permits the appointment of one or more of the company's members to the office of Managing Director and allows the Board of Directors to determine the remuneration of the appointee. Thus, where these articles apply, a director's salaries and allowances do not have to be approved by members in a general meeting, and could only be amended by special resolution, which is difficult for members of a large company as they have to garner a 3/4 majority vote in order to pass it. Plus, the lack of mandatory approval by shareholders impliedly makes it permissible for a company's articles to further empower the board by allowing them to determine executive directors' terms in their contracts of service. This leads to less impartiality, as overindulgent boards that favor their colleagues may confer too generous financial benefits to executive directors who are also board members. Therefore, this lack of limitation and transparency makes shareholders more prone to lower dividend payouts due to the possible mismanagement of financial resources. Under the Revamped Companies Act 2016, Section 230 provides that the fees and any benefits payable to the directors shall be approved by members at a general meeting for public companies. Unlike the 1965 Act, there is a mandatory provision requiring the remuneration of public companies' directors to be approved by the members in a general meeting. This means that a public company's constitution can no longer give its board the power to fix the remuneration of its directors. Rather, it must be approved by members in a general meeting. Therefore, members of public companies have direct control over directors' fees and other benefits paid to the directors, which they may use to establish proper procedures in deciding the remuneration quantum, as recommended by the Corporate Law Reform Committee. Section 232 further gives a statutory right to shareholders of public companies to inspect directors' contracts or services, increasing oversight in general for executive directors. All of this works as a mechanism that ensures accountability and transparency on the part of directors in determining their remuneration. On the other hand, Section 230 subsection 2 governs directors' remuneration for private companies, which provides that the board of directors may, subject to the Constitution, approve the fees of the directors and the benefits payable to them. Subsection 3 further stipulates that an approval by the board made under subsection 2 shall be recorded in the minutes of the directors' meetings, and the board shall notify the shareholders of the approval of the fees within 14 days. While the board retains the power to fix the remuneration of its directors, it will be issued with a mandate to record the approval of the fees in meeting minutes and to notify the shareholder of such approvals. Furthermore, pursuant to subsection 4, members holding at least 10% of the total voting rights who consider the payment to be unfair to the company may, within 30 days of knowledge of the payment, require the company to pass either a written resolution or one by general meeting to approve it. Unless such approval is obtained, the payment shall be a debt due by the director to the company. All of this ensures a check and balance system to prevent boards from fixing overly indulgent remuneration schemes to its directors. Clearly, these provisions provide greater clarity about regulating directors' remuneration, which tremendously improves the previous position of merely being regulated by articles. Lode and Knorr further found that a board of directors structure highly correlates with directors' remuneration and accountability for effective communication to shareholders. Thus, refining remuneration procedures enhances shareholder rights through transparency. Since executive remuneration is negatively associated with dividend payout, this transparency also becomes integral in maintaining the company's funds and preventing it from being misused. Ultimately, it inadvertently refines and strengthens procedures related to dividends for shareholders by maintaining a legitimate dividend payout ratio which relates to point 4 of Policy Statement 9. In conclusion, there are still issues with the Companies Act 2016. Voting rights on preference shareholders require more clarification, whereas statutory derivative action and variation of class rights requires reformation due to its lack of impact. However, overall, the changes made by the 2016 Act are satisfactory in enhancing shareholder rights as well as their protection under Policy Statement 9. Therefore, it is still successful in achieving its objective to a reasonable extent due to its various provisions. This is the end of our company law presentation. Thank you very much for watching.